It's the state's understanding that both Ms. Ortiz and Mr. Taylor are present, and the parties are in agreement with regard to the financial matters, Your Honor. Specifically, Ms. Ortiz is not seeking back child support, and the state has no objection to that. There's no disagreement over Mr. Taylor's income, which would make child support in this case $264 per month beginning August 1st, and medical support would be $59 a month, also beginning August 1st, based on the mother maintaining government medical for the children. It's the state's understanding that the contested issues are with regard to type of conservatorship. Mother is seeking to be named sole managing, while Mr. Taylor would like the parties to be joint managing conservators. The state is seeking an appropriate ruling from the court based on the existence of that protective order. I believe testimony will show that there was also a recent criminal conviction of Mr. Taylor for continuous abuse that resulted in incarceration, but it was not involving the children or other parent in this case. Additionally, Your Honor, it's the state's understanding that visitation is at issue with regard to the father seeking standard possession order, while mother is asking that it be exchanged at a police department by designated third parties. She's also asking for non-disclosure. And while the protective order is in place until February of 2026, if there is allowed to be any communication regarding the children, mother is asking that this occur via app close.
All right, well, I'll let you introduce it. Looks like it's a district court protective order, so yeah, 2 years and a whole lot of restrictions. So we'll go ahead and take all this up at this time. Here's the deal, Mr. Taylor. The law is pretty clear. If there's a protective order out on you on any person, not only the person who's before the court this time on the other side of your case, but any protective order that makes a finding of family violence there under Texas law, you can't be named the joint managing conservator. That's just a straight out and out law. And you can make the oral arguments all you wish for such, sir, but again, based on the law, I can't do it. All right. But I will go ahead and listen to what y'all want to try to do here today, what the circumstances are, and I'll see whether or not we're going to make this a final order or whether or not I'm going to go ahead and appoint an attorney to represent the kids to make sure that all matters are considered before the court, and all matters as far as the protective orders and convictions that may or may not be out there are considered, and whether or not what those terms and conditions are, and based on those, the court will have to cherry pick what rights that the non-considerable party may get under this order. So at this time, I'm gonna go ahead and get, and my understanding is all matters are final. The criminal matter is final, the child support, the protective order matter is final. And I want to confirm that with Mr. Taylor to make sure that we're not gonna have to have him testify to anything that may be a violation of his Fifth Amendment rights against self-incrimination.
Take first calls, Ms. Ortiz. Ma'am, what is your full name?
Krista Lee Ortiz.
Who are the children in this case?
Maylee Taylor and Stephen Taylor III.
How are you related to them?
I'm their mother.
And ma'am, who is the father of these children?
Stephen Taylor Jr.
And ma'am, is it correct that for each of these children, you and Mr. Taylor signed a document called an acknowledgement of paternity, admitting that you are their parents?
Correct.
And were you able to hear my opening statement to the court just now, ma'am?
Yes.
Was that an accurate description of the facts and issues and relief you believe that we would be bringing to the judge for ultimate decision?
Yes.
And so, ma'am, at this time, are you aware of Mr. Taylor having any pending criminal matters or anything relating to the protective order that's still going to go in the future?
Not that I'm aware of.
And then, ma'am, as far as the protective order, this was obtained from the 478th District Court of Bell County, Texas. Is that correct?
Yes.
And that document that I provided to the court is one that you had previously submitted to my office for consideration?
Yes.
Your Honor, at this time, I ask the court to take judicial notice of that order in the different cause number submitted by the mother, Miss Ortiz.
All right, technically, folks, this is not technically really evidence. This is a court order from a different court file over in Bell County. And the court is looking at considering it. Is there any legal reason that the court should not be able to consider this, Ms. Ortiz?
No.
Mr. Taylor, is there a legal reason why the court should not take judicial notice of Judge Faulkner's order?
No.
All right, the court is taking judicial notice of the Judge Faulkner's order from the under cause number 344,506. I'm pretty sure it's either 23 DFAM or 24 DFAM at the beginning, but that's the actual cause number. And this was a protective order that involves the two parties here. And there was a finding of family violence in this. And this was actually signed off on by Judge Faulkner back on 2/26/24. And it appears to be a 2-year protective order. So the court will note that for the record and allow the state to proceed. Thank you.
Excuse me, Your
Thank
Honor, I
you.
have a question for you.
All right, sir, it's not the, okay, I'll go ahead and let you ask the question at this time, just in case you need some clarification. Yes, sir, what's the question?
You said there was family violence. I never got in contact. I didn't go to jail for no family violence. I went to jail for terrorist threat.
Okay, here's the deal, sir. The order itself is an order for family violence, sir. I'm not saying you went to jail for it. I'm just saying the protective order makes that finding.
And you said I went to jail. The reason I went to jail for was what?
Okay, the state said that in the opening statement that there was another criminal charge that you were actually charged with, and I'll let the state refer to that specifically and explain what that is and when it comes up at that point, sir. But my understanding is that you have been convicted of a matter that makes you have to be registered as a offender in the state of Texas, but we'll verify that one way or the other, sir. We haven't gotten there yet, okay?
That's incorrect, though. I mean,
okay,
Mr.
Taylor. Okay, Mr. Taylor, I'm not going to argue with you here today, sir. This is not the way we work. If you can make, when it's your turn to testify, you'll get a chance to tell the court your side of the story and tell the court what's out there one way or the other. But this time, I'm going to let the state proceed. Mr. Taylor?
I said, I understand that this is affecting my
children.
children.
Mr. Taylor, order in the court, Mr. Taylor. You're getting ready to get held in contempt, sir. I told you it's not your turn to testify. Stop immediately. Otherwise, I can hold you in contempt and I can send you over to jail today for failure for being in contempt of court. Mr. Taylor, you'll get your chance to tell your side of the story, but you're not the witness right now. I took you out of turn to make sure there's nothing I had to clarify. But at this point, sir, don't say another word until you're called as a witness. Thank you. State may proceed.
Thank you, Your Honor. Ms. Ortiz, do you have any information about Mr. Taylor's criminal convictions?
I do. They were for terroristic threat, and the threats were all made against me.
Okay, and that's the only thing you're aware of that Mr. Taylor has been convicted of and that he went to jail for?
The only other one, it was 2 different charges, and those were both criminal trespassing, and they were for me as well, because I did a criminal trespass and he violated it.
Okay, so that part of my opening statement was inaccurate, correct?
Which part was it?
Where I mentioned continuous abuse.
Correct. Yeah, I didn't hear that part.
Okay. Moving on, ma'am, to the few agreements you and Mr. Taylor do have.
And real quick, ma'am, those 2 items that you testified to, they are final and in the book judgments, correct?
Yes.
All right, thank you. You may proceed then, Ms. Mongat.
Yes, Your Honor. Ms. Ortiz, how do your children have health coverage at this time?
Medicaid.
And you're comfortable maintaining that going forward while Mr. Taylor pays the cash medical support as you'd agreed to?
Yes.
And that $59 a month, ma'am, you understand that to be based on his income and the fact that he has no other minor children?
Yes.
Which would make his current child support amount $264 per month?
Yes.
And you understand that the state's requesting that both of these amounts begin on August 1, 2024?
Yes.
And you are not asking for any retroactive or back child support at this time, is that correct?
Correct.
Any particular reason, ma'am?
No, I mean, he was helping me financially. I feel like he would help me financially if I needed it, so I just didn't ask for it.
Okay. And then, ma'am, is it fair to say that your biggest concerns for this order would be with regard to the rights and duties you each have to your children, and then what type of possession or access Mr. Taylor gets?
I'm okay with the standard visitation. I just wasn't sure how it would work as far as like a pickup and drop off because of the protective order. And so when I spoke with the lady who helped me at first, she just said that normally it's done at like a central location, like the police department, and then like a third party would do the pickup and drop off. And I told her that I was fine with that.
Okay. And ma'am, what's the distance between your two homes at this time?
I'm not, maybe about 30, 40 miles.
Okay. And one of your concerns also, ma'am, was having to disclose your address or update Mr. Taylor if any of your information changed. Was that accurate?
They advised me to do so, but I mean, I live in the same home where we live together, so he already has the information.
And you no longer have any concerns so that if you move from your current residence, you'd have no problem updating Mr. Taylor of that place?
Correct.
Okay. What method, if any, have the two of you used to communicate since the protective order went into place?
We haven't been communicating, but he has had open communication with the children. I have an older daughter, who is 16. He is not her biological father, but she's able to communicate with him. And then for the younger ones, my younger one does have a phone, so he has access to communicate with her as well.
And how old are the two younger ones?
7 and 4.
And so, ma'am, based on the proximity and his awareness of your current address, you requesting that exchanges occur at the local police department by somebody you designate, such as, well, someone you designate would work for you, so he does in fact have time with the children.
Correct.
With regard to the protective order, did it place any conditions on him in terms of being around them or having time?
Not with the children. It was just against me.
And so as far as them being listed as protected persons, this was mainly due to them being in your same household?
I'm guessing because from what I understood, he was able to have contact with them. He just wasn't able to have any contact with me or
Okay.
attempt any communication.
Ma'am, I'm still reading over your protective order, and it appears that the district judge ordered no contact until further order, even with the children, but he gave the district court the specific rights to do so, or another court of proper jurisdiction, which is this court, so we can deal with visitation going forward, it looks like. But I want to read the whole thing and make sure there's not something that contradicts what I just said, all right? Thank you.
Okay.
You may proceed, Ms. Mongat.
Thank you, Your Honor. Was there anything else, Ms. Ortiz, you wanted the court to consider based on my questions or my opening statement?
No.
Thank you, ma'am. Your Honor, I pass this witness.
All right, Mr. Taylor, the state's getting ready to call you as a witness. It appears that there's no pending charges, so there's nothing against self-incrimination that is necessary. And the mother clarified that there are no convictions that involve you being registered as a offender. Only the protective order and the trespass and the second and a second charge. And and again, it appears to be a family violence, the charge on that one also. But anyway, I'll go ahead and let the state now call you as a witness, sir. Please listen to the questions, answer the questions to the best of your knowledge, sir, and the best of your recollection. If you don't know the answer, just let us know. You don't know, okay? And we'll move on, or the state will rephrase in an attempt to get this done. But again, sir, I am specifically looking at your protective order right now. It does specifically find that you have committed an act of family violence, and it spells that out specifically. And it does appear to allow this court to court order visitation, but it also appears to order that you're not allowed to come anywhere within 200 yards of the mother's residence or her place of business. And I'm double checking to see whether or not you're allowed anywhere near the children's school, but I'm going to go through the rest of the protective order to make to double check that. Well, at this time, I'll go ahead and let the state call you as a witness. And if you have any questions at the end of this testimony, sir, you could, based on these prior orders, you'll allow you to ask those questions at that time. But this time, just again, listen to the question and answer the question, and we'll see, and we'll try to get through this one. Thank you.
Thank you, Your Honor. The state calls Mr. Taylor. Sir, what is your full name?
Stephen Eugene Taylor Jr.
And sir, is it correct that you're the father of the 2 children in this case with Miss Ortiz?
Yep.
And sir, you do not have anything pending criminally or with a protective order at this time, correct?
No, I don't.
And sir, were you aware of that protective order obtained by Miss Ortiz in February of this year?
Yes.
And based on that, sir, have you had any opportunities to spend time with your children since then?
None whatsoever.
And is it correct, sir, that you are wanting this court to consider awarding you the standard possession order or whatever you and the mother could agree to?
Yes.
And would you agree to the distance between your 2 homes?
Yes.
Would you have any problem, sir, picking up your children from the local police department, whether it was Miss Ortiz herself or somebody else being the person to bring the children?
No.
As far as the financial matters, were you in agreement with the child support and medical support calculated based on your income and no other children?
Yes.
And sir, does your employment offer any private health or dental insurance?
None.
And as far as your physical address or other contact information, would you have any problem, sir, with it appearing in the court's order?
What was that?
Would you have any problem with your physical address or other contact information appearing in the court's order?
No.
And are you comfortable updating Miss Ortiz if any of it changes?
Yes.
And sir, what method of communication would you want to use if not app close or whatever the court decides to order?
What do you mean, with my kids?
No, sir. If you were needing to talk to Ms. Ortiz, the other parent, about anything regarding the children, assuming that that's not a violation of the protective order, would you have any problem with app close, or are you requesting something different?
I mean, we could talk in person. Everything's fine. I don't mean nothing wrong. We could talk on the phone. Nothing's wrong. I mean, as far as the order is, I mean, it's a waste of order, to tell you the truth.
Okay.
Any kind of communication be fine. Doesn't matter. Whatever she wants, whatever she needs, she got it.
All right, Mr. Taylor, what the court normally does in these circumstances is ordering a parenting app that can actually be used as evidence in a court going forward, just in case we get into one of those he said, she said circumstances, especially with you having a protective order against you, because this violation of protective order under Texas law means you can actually be held in contempt and charged criminally. So there's two different jail sentences that can go against you. So again, app close is a parenting app that allows you to text, FaceTime, does other things, but it also makes complete documentation of the time, place, and circumstances. That way, in case it ever has to be introduced in court as evidence to show that something did or did not happen, it's available to either of you. So that's why the court normally uses it. And I'm looking at using it in this case, especially since there is a protective order, sir. So do you have a problem with using the parenting app to communicate with the mom, and it's only with the mom going forward, sir?
No.
All right, thank you then. You may proceed, Ms. Von Gatt.
Thank you, Your Honor. And sir, when you were talking about your incarceration, are you on probation of any kind?
Nothing at all.
Thank you, sir. Have you ever served in the military, Mr. Taylor?
No, ma'am.
Have you ever received any type of disability finding?
No, ma'am.
Thank you, sir. Your Honor, I pass this witness.
All right. Is there anything else you want to tell the court at this point, Mr. Taylor? I think I may have a couple of questions, but I want to hear if there's anything else you have that you want to ask the court this time, sir.
I got nothing to ask, man. Nothing I can say, nothing I can do at this point. I mean, just want to see my kids. That's it. That's all I care about.
All right, then, sir. And which city do you live in at this time, sir?
Toledo.
Okay, then. All right then, sir. Ma'am, which city do you live in?
Bartlett.
Bartlett. Okay. All right, I haven't dealt with the Bartlett Police Department in a while. I don't think I've done it twice, but I know they got one, so this will still work. All right then. Ms. Bongad, is there anything else that state any other questions for either witness at this time, Ms. Bongad?
No, Your Honor.
All right then. I don't see a reason to make this but it's probably couldn't be a final based on the circumstances. When I get through making my ruling on everything, folks, I'll go ahead and let y'all declare whether or not y'all want this to be a final order, or do you want it to be a temporary order to see how it works, to see if we need to tweak anything. And if I do make it a temp, I'll probably will appoint a lawyer to represent the kids just to be on the safe side. But for right now, I don't, with everything being finalized as far as the criminal side and protective order side, there's probably not much I can do different than in the future than I can do right now. So I'll go ahead and let the state make a closing statement to tell the court what they're requesting, and then I'll allow both of you to add anything else y'all think is appropriate. And I am looking at going ahead and ordering an app close, ma'am, which means that you have to download it to your smart device. It's available both on Google Play and iTunes, and set up the account. And then tell you what, I will appoint it ad litem, but only for the purposes, not for a temporary order, but only for the purposes of making sure everybody gets set up on app close, and there's not any problem with that. Mr. Taylor, did you have a court of order counsel in any of your criminal matters, sir?
What's that?
Did you have a lawyer representing you in any of those matters that you have been convicted of, sir?
No.
You did not? All right, thank you. Just want to make sure I didn't get somebody that would be in conflict. All right, Ms. Bongat, I'll ask for your closing at this time. Thank you.
Thank you, Your Honor. The state is asking that this court approve the parties' agreements with regard to current child support of $264, current cash medical support of $59 per month, both of these to start August 1st of 2024. The court approved no retroactive support as requested by the mother. That the court make appropriate rulings for the conservatorship of the children, for the visitation or possession and access, exchanges, and that the court make an appropriate ruling with regard to court costs.
All right, then. Anything else you think I need to know at this time, Mr. Taylor?
None.
Anything else, Ms. Ortiz?
No.
All right, folks, I'm looking back, based on Texas law, I'm looking at naming the mother sole managing conservator of the children going forward. I'm naming the father possessory conservator. I'll have the state double check, and I'll go ahead and what rights may be affected by the protective order. I'm going to ask that you actually have this one set up and send this one via DocuSign instead of e-file. That way I'll see it come in, and I can double check to make sure there's nothing I need to have tweaked, and do that before you send it out to the parties for their signatures. But I'm gonna go ahead and, like I said, name mom sole MC, dad possessory conservator. I'll give him all the rights of the possessory conservatorship that don't violate or are in conflict with his protective order. I'm gonna go ahead and order him to pay child support and cash medical support as agreed to. What was the start date on that, Ms. Mongat?
August 1st, Your Honor.
All right, starting August the 1st, 2024. I'm gonna go ahead and give the father standard possession and access to the children. They live within 100 miles, within 50 miles of each other. So I'll give him a standard possession order, and that's the first 35th weekends of the month. But they don't live in the same state, so I'll make it the first 35th weekends of the month, starting on the 1st, 3rd, and 5th Fridays of the month, which means this coming Friday, I think, is the 2nd Friday of the month. So the following Friday, that the 19th will be the first visitation period with the father. We're already through summer visitation, so we're just going to go with the weekends until next summer. So I'll go ahead and give him, like I said, the 1st, 3rd, and 5th Fridays of the month, starting at 6 p.m. on Friday, going to 6 p.m. on Sunday. I'm going to make the exchange spot at the Bartlett Police Department. Address is 202 North Dalton Street, Bartlett, Texas, 76511. That's 202 North Dalton Street, 76511 is the zip. I'm going to go ahead and, like I said, order that the father send via I'm sorry, I say DocuSign, by app close, the request that he is going to, he wants each of the visitation period. Here's the deal, sir. The first visitation is set for next Friday at 6 p.m. You need to let mom know at least 48 hours in advance, which means by 6 p.m. on the Wednesday before each visitation period, that you want your visitation as far as the weekend is concerned. Mom will have either her designated agent or she will have the children at the police department at the appropriate time. Under Texas law, she has to remain there at least 30, or whoever the party is going to do it, has to remain there at least 30 minutes. If you're more than 30 minutes late, they don't have to remain there, sir. So always make sure you're on time. Or if you're running late via the app close app, the texting function on it, let them know that you're running late. That way they can make appropriate plans to be there if you're running a little late. But the bottom line is this kind of works on everybody being on time, since we got to make these changes at a neutral spot. And again, sir, you can use a designated agent to pick the kids up if you wish, so long as the person is an adult over the age of 18 and does not have any criminal convictions of their own. So that's the weekend business. Obviously, you're entitled to the holidays and the under the order, and next summer you're entitled to the regular summer visitation. I'm going to go ahead and again, like I said, order everybody to app close. I'm going to go ahead and I'm going to appoint. Let's go with Mr. Bramhall on this to make sure everybody gets set up with app close. I'm going to go ahead and appoint a lawyer named Isaac Bramhall to be the ad litem for your children in this matter. He's not going to do an investigation. He's only going to do the necessary work to make sure both of you can technically set up the app on your telephones, and to make sure it's set up properly and everybody's communicating with each other properly. Going forward, so long as that protective order is in effect, and the protective order is in effect until February of 2026, I'm going to order that, going forward, no matter what, that y'all use app close as far as your source of communication. That way, we won't get into anything that can't be verified. Everybody, please use the app, and that way there won't be any problems in there. And that will avoid the prospect of somebody going against Mr. Taylor because they allege that he violated the protective order. And that, again, Mr. Taylor, Miss Ortiz may not be the one to do that. That's left up individually to police departments and prosecutors. So that's why I'm doing this, because I'm doing this just as much for her protection as your protection, to make sure nothing happens in the future that gets you in trouble. So Mr. Bramhall will be in contact with both of y'all. I'm going to make sure Ms. Ortiz is it okay with the state to give Mr. Bramhall your phone number and your email address, ma'am?
Yes.
All right, Mr. Taylor, is that okay with you also, sir?
Yeah.
All right then. All right, folks, and on this one, I'm going to go, since the father has been supporting, mom testified that dad has been supporting the kids, I'm going to go ahead and waive court costs. So at this time, I'm going to start with you, Ms. Ortiz. Any questions, anything you think I need to clarify, ma'am?
No.
All right, Mr. Taylor, any questions, anything you think I need to clarify, sir?
No.
All right, Ms. Bongat, anything else, ma'am?
And Your Honor, was the court making a ruling on non-disclosure?
I think the protective order covers that, so I'm granting non-disclosure, okay?
Yes,
I
Your
don't want
Honor.
to violate the protective order, so. All right, folks, I'm gonna go ahead and, like I said, if Mr. Bramhall's information will be in the court order that I'm gonna sign off on, it'll be sent to y'all. So if he hasn't gotten in contact with y'all by the by this coming Friday, everybody get in touch with him by next Monday, okay? And let him make sure he gets everything set up so y'all know how to do it. But right now, both of you can go, if you got an iPhone or you got an Android phone, you both can go on the Google Play or the iTunes store and download the app close. It's spelled APPCLOSE. It's free. It's the #1 parenting app in the country. So and you can go ahead and there's probably a couple videos out there on how to set it up, but I'm going to make sure Mr. There's a lawyer representing the children, Mr. Bramhall, that'll make sure it's set up, and that way we won't have to worry about that there have been technical difficulties with this getting done. So at this time, Ms. Bongat, is there anything else, or can the parties be excused?
Your Honor, since this is a final order and Mr. Brimhall's appointment is limited in scope, is he automatically released after the 30-day period, or are you going shorter?
He's automatically released after the 30-day period, just in case something happens within that 30 days. There's a technical problem with the app, and either one of them is still contacting him up until the day is the 9th day of July. So Mr. Brimhall is technically on still the children's lawyer until the 8th day of August. Okay.
Yes, Your Honor. Thank you.
All right. All right, thank you both very much. You're both free to go, and like I said, you'll be getting a copy of the order. And Mr. Brimhall should be getting in contact with y'all but before the week's end. Okay. Thank you.
Okay, thank you.
All right, thank you both very much. We're off the record. Good luck to you and the kids.
Thank you.